The Goshen and Mona Water Dispute, 1873 to 1881, a case study of the struggle between ecclesiastical and secular authority in Utah. By Clinton Brimhall and Sandra Dawn Brimhall. In one of her short stories, Where Nothing Is Long Ago, Mormon author Virginia E. Sorensen wrote about a farmer who killed his neighbor with a shovel during a dispute concerning irrigation water. Sorensen posed the question, if a thief enters a man's own house in the night and means to rob him of all he has, all his clothes and all his food, thereby meaning to take the very lives of his wife and his little children, then what shall that householder do? Is it not true that he who steals water is stealing life itself? Born and raised in Utah during the early 20th century, Sorensen knew some of the early pioneers who talked about the wide, dry wastes before the mountain water was captured and put to use. The pioneers, like Sorensen, learned from hard experience that the dry spaces, where jackrabbits hop through brush, as thick as mites on a hen, are always there, waiting to take over. Dryness hugs the green fields, pulsing in, only the irrigation ditches keep it at bay. Sorensen's account of a deadly quarrel over water was fictional, but her perception that it has always been a precious commodity in the arid West is fact. One interesting and far-reaching clash regarding water rights occurred between the two Utah Mormon towns of Goshen and Mona during the 1870s and early 1880s. The residents of both towns were nearly all members of the Church of Jesus Christ of Latter-day Saints, and when local church leaders were unable to resolve the contested issue, the conflict escalated into a lawsuit instigated by the Goshen Irrigation and Canal Company against the Mona Canal Company. As a result of Goshen's decision to file the lawsuit contrary to church leaders' counsel, Goshen's LDS ward bishop, William Price, and his counselors John Rouse and Paul Gorley were removed from their church positions, and most of the ward members were disfellowshipped or excommunicated from the church. The Goshen and Mona water dispute, and its eventual resolution, provides a case study of the struggle between ecclesiastical and secular authority in Utah during the late 19th century. In addition, this case demonstrates the difficulties church and government leaders experienced when attempting to provide an equitable distribution of water between old and new settlers in a community and between neighboring settlements. Goshen Valley, located in Utah County just south of Utah Lake, was explored in the spring of 1856 by Phineas Cook and several other men while searching for stray cattle. Cook found the rich soil, abundant natural resources, and a fairly large creek that entered the valley from the south. He obtained permission from Brigham Young to establish a new settlement in Goshen Valley. A few months later, Cook and about 25 men returned and spent the summer building an irrigation dam across the creek, then known as Little Salt Creek, now Current Creek. Most of the men returned to their homes before winter, but Cook and a few others remained in the valley. The next spring, 10 families built a fort and established a permanent settlement on the east side of the creek, approximately 2 miles north of the present site of Goshen. By the end of the summer, they were joined by 10 additional families. The settlers named their town Fort Sodom, because the fort had been constructed with large cedar posts and filled in with sod from a nearby meadow. Cook was chosen by Brigham Young to serve as presiding elder of the branch, with John Rouse and John Reynolds as counselors. During that first year, very little was grown because the virgin land had to be cleared of brush, irrigation ditches made, and seed planted. The following year, the settlers diverted the entire flow of the creek to irrigate the 200 acres they cultivated. In subsequent years, much more acreage was irrigated from water stored in a community-built dam. In the fall of 1859, the colonists abandoned Fort Sodom because of unhealthy conditions and boggy land and established a new settlement on the bench land approximately 1 mile southwest of the fort. The new site, which they named Sandtown, also turned out to be uninhabitable because of wind and sand. The next year, the settlers moved to another location, named Lower Goshen, which was situated approximately 1½ miles northwest of the original fort. As a result of the frequent moves and difficult conditions, a lack of unity developed among the people and Cook was released from his position as presiding elder. On February 15, 1860, William Price, who resided in Salt Lake City, was ordained bishop and appointed to preside over the Goshen ward. Price, a brother-in-law of Brigham Young, was, according to family oral tradition, selected by Young to quell rebel church members in the town. Before receiving the call, Price had co-owned a general merchandise business with church apostle Orson Hyde. After being ordained, Price immediately sold his holdings and went directly to Goshen, traveling with Hyde. They arrived in Goshen on February 17, 1860. Like previous Mormon settlements, Lower Goshen seemed promising. The settlers surveyed and divided up the land, built adobe houses from nearby white clay beds, and their farms yielded a good harvest during the first several years of settlement. Improvements also were made to the dam. A large ditch, varying in width from 7 to 12 feet and in depth from 2 feet to 4 feet, was made on the west side of the creek to the meadows, which provided the small farms with irrigation water. Although the residents were successful in raising grain, corn and potatoes, they discovered the soil was too alkaline for gardens as well as for fruit and shade trees. During a visit to Lower Goshen in 1867, Brigham Young selected a new town site for the residents. By November 1869, all but one of the settlers had relocated to the new location. The settlement, Goshen, continued to receive water from the dam, but as the population increased and more land was cultivated, the need to increase the dam's output became more acute. In 1871, the dam was reinforced and additional outlets made from the dam. The town also organized a water board which systematically measured the available amount of water in the various ditches. Shares of water were issued to individuals according to certain regulations and requirements agreed upon. Although it was common during this period for Mormon bishops to organize and supervise these types of endeavors in their wards and communities, Goshen records and histories do not describe the extent of Price's involvement with the dam or irrigation projects. Instead, Hugh McKee was appointed water master. He established an irrigation schedule to make sure that everyone received a fair share of water. About this same time, some Mona residents, perhaps unaware of Goshen's claim, also began using water from Salt Creek upstream from the Goshen Dam. Their action deprived Goshen farmers of the water they had relied on, and trouble surfaced almost immediately. Mona, formerly known as Clover Creek, located in Juab County approximately 10 miles southeast of Goshen, was originally settled several years before Goshen in February 1852. The settlement, however, was temporarily abandoned in 1853 during the Walker War when settlers moved to Nephi for safety. In 1860, the town was resettled, and a few years later, and at Brigham Young's suggestion, Mona was relocated a few miles east to a healthier location. The new town was surveyed in 1867 and artesian wells were dug to obtain drinking water. Farming began on the East Bench with irrigation water coming from Empty Nebo. John Madison Hawes and Edward Kay were appointed the first water presidents for the town. Two of the principal players on the Mona side of the dispute were Howard and Martha Jane Knowlton Corey. The Coreys had joined the LDS Church in 1840 and gathered with other church members in Nauvoo. Howard was a personal friend of Joseph Smith and served as one of his clerks, assisting the prophet in compiling material for the history of the church. Martha aided the prophet's mother, Lucy Mack Smith, in writing her son's biography. After arriving in Utah with the John Sharp Company in 1850, the couple resided in Salt Lake City and Tooele before settling in Provo in 1857. Prior to moving to Provo, Howard was employed as a clerk for LDS presiding Bishop Edward Hunter in Salt Lake City for 5 years. He also worked as an accountant, teacher, farmer, and operated a molasses factory and sawmill. Martha served as the first secretary of Salt Lake City's 13th Ward Women's Relief Society, which was organized in 1854. Possessed of a keen intellect, Martha published articles in the Woman's Exponent, and her unpublished letters and journal reveal a sound understanding of the law. She also had an aptitude for medicine and distilled a variety of different herbs to produce medicines and liniments that she marketed from Nephi to Ogden. When Howard moved to Mona in 1871 to homestead a ranch, Martha remained in Provo but traveled frequently between Mona and Provo. In 1875, Martha was appointed as the only female member of the Brigham Young Academy's first Board of Trustees, chaired by Abraham O. Smoot. Smoot also served as president of the Utah LDS stake, which had jurisdiction over Goshen. It appears the Coreys played a primary role in the creation and management of a canal company in Mona that was independent of earlier irrigation projects which had obtained water from wells and runoff from Empty Nebo. Entries in Martha's journal reveal that during the fall of 1873, Howard and several of his sons surveyed a dam site, began hauling rock for the dam, and laid out a water ditch west of Salt Creek and upstream from Goshen. The first indication in Martha's journal of trouble between Goshen and Mona was recorded on January 24, 1875. I saw B.P. Smoot about Goshen's claim against us, sent letter to President Young. 2 months later she wrote, Mr. Corey wrote to Goshen Committee through Bishop Price, the refusal to acknowledge their jurisdiction. Subsequent journal entries document additional meetings with the Goshen men and further consultations with Smoot. On April 18, 1877, Goshen residents formed and registered a corporation, which they named the Goshen Irrigation and Canal Company. The first officers of the corporation were John Burriston, also spelled Buraston, Jörn Jasperson, Powell Powelson, also spelled Powell Powelson, John Morgan, and Richard Johnson. The formal incorporation was probably done in anticipation of a lawsuit because 6 months later, on October 20, 1877, the Goshen Irrigation and Canal Company filed a lawsuit in the First Judicial District Court against the Mona Canal Company. In the complaint, the Goshen Irrigation and Canal Company alleged that in 1858 Goshen residents had constructed a dam on Lower Salt Creek and all the necessary ditches to use all of the water from the stream for the use of the inhabitants of the town. And, although the town was relocated several times, the inhabitants continued to use the water from the dam, except during 1862 to 1863 when there was an unusually large amount of water in the creek. The Goshen Canal Company regularly maintained and repaired the dam as was necessary. The complaint further alleged that in 1873 the Mona Canal Company constructed a dam across the stream, west of Mona, about 10 miles upstream from the Goshen Dam. The basis for the suit was that the Mona Canal Company's dam stored and diverted large quantities of water from the stream, and despite protests, the dam caused great and irreparable injury to the Goshen Irrigation and Canal Company and those it represented. The Mona Canal Company seemed intent on continuing to divert the water. Corey a week later following the filing of the lawsuit recorded in her journal that Pa, Howard Corey, and John Madison, went to see George, Teasdale and Joel Grover about water business. Pa got letter from Grover and Teasdale to William, Price and Henry Snow. Hus began serving as Mona's bishop in 1877 and Grover served as the Juab stake president from November 10, 1871, to July 1, 1877. Teasdale succeeded Grover and served as the Juab stake president until October 12, 1882, when he was called to the LDS Quorum of the 12 Apostles. The Coreys delivered the letter from Grover and Teasdale to Price on October 28, and 3 days later, Martha paid a visit to the LDS Church's presiding bishop, Edward Hunter, and obtained another letter for Price. After Howard brought home the legal papers concerning the lawsuit, he and Martha consulted with their attorney several times as well as with members of their canal company about the water problem. 8 days later, the Mona Canal Company responded to the Goshen Irrigation and Canal Company's suit with a motion to dismiss, alleging the complaint had failed to state facts that would justify a lawsuit. The Mona Canal Company also maintained the complaint was ambiguous, unintelligible, and uncertain. A month later, the Goshen Irrigation and Canal Company filed an amended complaint, which had only minor alterations from the original complaint. On December 31, 1877, the Mona Canal Company again moved to dismiss the amended complaint for the same reasons as the first, while arguing that the Goshen Irrigation and Canal Company had not incurred any damages or injury by the Mona Canal Company's actions. However, the complaint was not dismissed and witnesses were deposed in December 1877 and again in February 1878. Still others, including Howard and Martha Corey, continued to seek settlement of the dispute through church leaders instead of the courts. Church leaders were strongly opposed to members taking legal action against their brethren in the Gentile courts, maintaining that church members should resolve differences through church courts, especially bishops' courts, where a higher law could be followed that relied heavily upon an inherent sense of justice rather than on technicalities based upon legal precedent. This ecclesiastical admonition prevailed in all areas of dispute, including water law. Historically, the common law doctrine of riparian water rights, used in the eastern United States, maintained that property owners who owned land next to streams had the natural right to use the water in its natural flow, in cooperation with other landowners who had the rights of coequal use. In the arid West, however, where water was not as plentiful, the territories and states rejected riparian water rights doctrine and substituted it with the doctrine of prior appropriation. Under the law of prior appropriation, the first appropriator was entitled to all of the water he had originally appropriated, even in times of scarcity, before a subsequent user was entitled to the water. Eventually, the West's doctrine of prior appropriation was modified so that, among other things, water rights could only be acquired for beneficial uses. Under this principle, appropriators could not claim more water than they needed for their crops, livestock, mines, mills, or domestic use. Brigham Young and his followers developed a water policy unique from the common law and Western practice. Water was viewed as a public, not private, resource. According to this view, the government allowed prior appropriators to use the water as a type of easement, but prohibited the absolute ownership of water. The Mormons, who had made a mass exodus to Utah and who expected thousands more to follow, realized that a first-come, first-served policy would seriously jeopardize any cooperative efforts to establish permanent settlements throughout the territory. According to George Thomas, an economic scholar and president of the University of Utah from 1921 to 1941, the Mormons were the first people to establish an extensive civilization in America with its economic basis resting almost wholly upon irrigation agriculture. In addition, they were among the first to develop laws, regulations, practices, and customs regarding water usage. On November 5, 1877, senior church apostle and acting church president John Taylor wrote a letter to William Price, informing him that he had been visited by some Mona residents regarding the water difficulties between Goshen and Mona. Taylor reported he also had conferred with Abraham Smoot concerning the matter and that he and Smoot were sorry to learn that you have commenced a lawsuit in relation to this matter, which we consider all good Latter-day Saints ought certainly to avoid. We ought to understand that we possess superior means of obtaining justice than those laid out by Gentile litigation. Taylor emphasized that as a bishop, Price should use every available means in his power to stop litigation on all subjects. Taylor suggested that, as an alternative, both sides could submit the dispute to an arbitration committee, comprised of persons from each county, which could amicably adjust the difficulty. Price in a return letter thanked Taylor for his letter and advice and then explained Goshen's reason for filing the lawsuit. It is evident the case has been misrepresented to you. We have tried many times to have them come to some terms by which an amicable settlement could be effected, but could not succeed. They refused plainly to acknowledge authority to any portion or individual in Utah Company with regard to their farming or irrigating in any respect and finally said that we had no right to the water. They were finally told that legal proceeding would be commenced to know who had a right to the water. "Bro," Corey replied, "that is just what we want, that is right into our hands." "Sis." Corey said she had a house and lot in Provo for which she could take $3,000 any day and that it was on hand to sustain a suit. "The people in this place have been very patient even when in some parts of the settlement there was no water to drink or to use for any purpose and our grain in the fields burning up. Our irrigating committee commenced such lawsuit against them about 2 years ago, but acting on the advice of President Smoot withdrew it since, and then they have acted worse and placed more dams on the creek, and now if they are not restrained the prospect is that this settlement will be broken up." In addition to the jurisdictional dispute, the Coreys also questioned if Goshen residents had met the legal requirement of prior appropriation. Martha recalled in her journal that a man named Haig had told them that in 1858, only 2 or 3 families were residing in Goshen and that they were using very little water. Despite their bluster, there is evidence the Coreys were worried about the outcome of the lawsuit because, in the spring of 1878, they began looking for alternate sources of water in North Canyon and Worm Creek. Martha recorded a flurry of other activities concerning the lawsuit from November 1877 to May 1878 that included correspondence and meetings with attorneys and members of the Mona Canal Company, and others such as Taylor, Price, Sharp, Hunter, Teasdale and L. John Nuttall. To help with legal expenses, Martha noted that shareholders in the Mona Canal Company were assessed $5 per share for the lawyers. On May 29, 1878, she wrote, "Trial set for 10 o'clock. All sides are ready and anxious, laid over indefinitely." On June 1 and 2, 1878, the LDS Church held a quarterly stake conference in Provo, which was attended by William Price, and probably some other church members from Goshen. On the first day of the conference, Apostle Daniel H. Wells instructed the saints that God's priesthood was the only government that was capable of successfully directing the energies of man in every department of life. The next day, when John Taylor spoke, he went a step further and rebuked priesthood holders for appealing to the courts to settle their difficulties and exhorted bishops and their counselors to be careful, just and impartial in their adjudications among the people. A few days later, Price wrote Taylor and described the Goshen ward members' response to Taylor's conference message. "I arrived home from Provo about 5 on Monday evening and found the brethren and sisters feeling very badly as the news of the conference preceded me. I have met with my counselors and the board of directors of the Irrigating Association, and will have a meeting of all the ward on Friday and lay the matter before them." In another part of the letter, Price denied an allegation by William Finch that he, Price, and his first counselor, Rouse, had forced Finch into the lawsuit. Price in a subsequent letter to Taylor stated, "In answer your letter respecting Bro. John Jenkins, he did not vote to have the Goshen water case continued in the district court. Jenkins appears to have changed his mind about participating in the lawsuit because he was one of the original shareholders in the Goshen Irrigation and Canal Company, and he apparently was one of the persons who had joined in the complaint when the action against the Mona Canal Company was filed." Unlike Jenkins, however, a majority of the Goshen ward members voted to continue the lawsuit, despite Taylor's rebuke and the possibility of suffering the consequences. The judge assigned to preside over the case was Philip Henry Emerson, who had been appointed as Associate Justice for Utah by President Ulysses S. Grant in 1873. Emerson served as a judge in the 1st District Court of Utah, Utah County, for 12 years, until his term expired in 1885. Local newspapers of the period described Emerson as a fair-minded, well-respected judge who, during his long judicial career in Utah, made few mistakes in the administration of the law. Despite Emerson's favorable reputation, LDS church leaders were wary of him as well as other federally appointed governors and judges, who, in their view, were guilty of harassment and spoliation. Beginning in 1862, the United States Congress had passed legislation which prohibited polygamy, divested the church of all assets in excess of $50,000, and assigned federal judges the jurisdiction over Utah's criminal and civil cases and allowed them considerable leeway in the selection of jurors. The federal government's political and judicial crusade against the LDS Church seemed to intensify during the mid-1870s, increasing the animosity between church and state. Adverse rulings in two high-profile cases, an 1873 divorce action against Brigham Young by one of his plural wives, and Eliza Webb Young, and an 1874 bigamy charge prosecuted by the government against George Reynolds, Brigham Young's private secretary, stunned Mormons and confirmed their fears about the difficulty of obtaining a fair trial in federal courts. Goshen's decision in 1877 to seek justice in one of these despised, Gentile, tribunals was unfortunate timing, to say the least. When the Goshen Irrigation and Canal Company v. Mona Canal Company case finally came to trial, on September 16, 1878, plaintiffs' counsels, John B. Milner and E. D. Hogue, and defendants' counsels, Joseph B. Roseborough and Samuel Merritt, waived the right to a jury trial and requested that the case be heard by Judge Emerson. During the proceedings, witnesses were examined on behalf of the Goshen Irrigation and Canal Company and the Mona Canal Company and, at the conclusion of their testimony, the judge heard arguments from counsel for the respective parties. After consideration, Emerson on January 4, 1879, entered a verdict for the Goshen Irrigation and Canal Company prohibiting the Mona Canal Company from diverting or taking, or using in any manner interfering with, or preventing the natural flow of, any, or all the water of said Little or Lower Salt Creek. The Mona Canal Company was also required to pay to the Goshen Company the sum of $359.20 to cover costs of the suit. Under the court's direction, U.S. Deputy Marshal Benjamin Bachman issued a notice on May 28, 1879, that all the right, title and interest of the Mona Canal Company in and to a certain dam across Salt Creek, near the town of Mona, Juab County, together with the canal, with all the gates, sluices, and other appurtenances belonging to said dam and canal, should be sold at a public sale at the front door of the Nephi Courthouse on June 21, 1879, at 10 o'clock a.m. On the day of the sale, Bachman auctioned off the assets of the Mona Canal Company for $391.63. Unhappy with the verdict, Martha wrote Taylor requesting that disciplinary action be taken by the High Council of the Salt Lake Stake of Zion against the Goshen Church members who were involved in the lawsuit. In response to Martha's request, the LDS Council of the 12 Apostles held a special session on March 3, 1880, to consider the Goshen-Mona question. Acting on behalf of John Taylor, John Nuttall wrote a letter to Abraham Smoot on March 8, 1880, communicating the results of that meeting. On motion, it was decided that the president of the Juab Stake of Zion, and the president of the Utah Stake of Zion, be instructed to call before their respective high councils, those members of the church, residing in their several stakes, who are charged or implicated in the Mona Goshen water case, to answer to the charge of going to the law in that case with their brethren, before the wicked and the ungodly contrary to counsel, sick. You will please take this matter in hand at your earliest convenience, pursuant to the above action. Taylor sent a follow-up letter to Smoot on March 30 with further instructions. He wrote Smoot that he, and other church leaders, considered Goshen's decision to file the lawsuit to be a flagrant rebellion against church authorities. Taylor laid the blame for the mutiny at the feet of Price, whom he felt evidently had not the firmness of manhood to stand up in defense of right and in magnifying his calling to which he had been ordained and elected. Taylor also advised Smoot that Price's counselors, Rouse and Gorley, who had voted flatly against obeying counsel, were not fit to be counselors to a bishop. The Mormon prophet emphasized that his displeasure concerning the case was not how it was adjudicated but that it was tried in a secular forum. I am not now speaking of the merits of the case, for I believe that the High Council of Utah Stake, or Juab Stake, would have given the same decision, or nearly so, as the court did, and we cannot see that being governed by the technicalities of the law that any other decision could have been given than was given by the court, thus showing that these parties gained nothing by this direct act of rebellion. Taylor stressed that although he and other church leaders felt no vindictive spirit towards the people of Goshen, they recommended that Price be temporarily suspended as Goshen's bishop and that his counselors be discontinued. He also advised Smoot to find a high priest in the ward who was not involved in the lawsuit and to appoint him to preside in the ward and to administer the sacrament to those whom you may consider worthy. The LDS Church's strict stand with Goshen church members was consistent with its policy in similar situations. The 1870s were a transition time in Utah from the cohesive and cooperative communities of the early pioneers, who were willing to submit to ecclesiastical authority, to the more diversified and independent communities of the next generation. According to LDS historians Leonard J. Arrington and Davis Bitton, during this period, activities once supervised by the bishop, schools, taxes, irrigation, business enterprises, judging civil dispute, were taken over by the state and local governments or by private enterprise. Taylor's condemnation of Price for not using his authority as bishop to prevent his ward members from airing their grievances before the ungodly demonstrates how church leaders struggled to keep the government from interfering in what had traditionally been ecclesiastical matters and to maintain the status quo. One example of this is a letter Nuttall wrote at Taylor's request to Isaac Furness on November 14, 1879, expressing concern about a problem Furness was having with his local leaders. Our impression is that if you do not insist on a public trial, that no one else will, and that all will pass off quietly. Furness was advised that if he would spend his time talking of the goodness of God and in trying to make peace, that brotherly love would abound instead of strife. In 1881, the Juab High Council heard a case similar to the dispute between Goshen Mona regarding old and new settlers' water rights. The early settlers of Levon, who claimed prior appropriation and continued use, were pitted against later settlers, who had labored to improve, maintain, and repair the infrastructure and had paid the water master for their share of the water. When the parties were unable to agree on a compromise, the local High Council chastised them and ordered that the old settlers be given 75 acres of thin water, divided, water rights, rather than the 150 acres they claimed. Although the parties appealed the decision to the First Presidency, Taylor affirmed the ruling. Wilford Woodruff in 1889 commented on another water problem that concerned him: "There come near being a war among the Latter-day Saints about the water going to law and going to shooting each other. I counseled, a meeting among them, and they met yesterday and today, which has calmed the elements considerable." Smoot and the Utah State High Council, acting on their own volition before receiving Taylor's March 30 letter, removed Price, Rouse and Gorley from their leadership positions on March 24, 1880. They also suspended from church membership all of the ward members who had supported the lawsuit. George Gorley, not to be confused with Paul Gorley who had been Price's counselor, was temporarily appointed to act as presiding high priest in the ward. One of the members suspended from church membership was Richard Johnson, an English convert who had been one of the directors of the Goshen Irrigation and Canal Company when it was incorporated on April 18, 1877. According to his descendants, it was a sad day in the Johnson family when Richard Johnson came home and told them he was no longer a member of the church. Johnson reacted to his suspension by temporarily returning to some of the bad habits, such as drinking and smoking, he had indulged in as a young man. After a few months, Johnson decided to return to church and to comply with church leaders' requirements. He got up in church and confessed his folly of going to court over the water. As a result, Johnson was one of the first to be rebaptized and accepted back into full fellowship. He later served a 2-year mission to England. From April through September 1880, 62 Goshen ward members, including Price and George Gorley, were rebaptized. A significant number of other Goshen ward members refused to comply with the church's requirements for rebaptism, and many left the community, never to return. Jørn Jasperson, his wife Julia, and 7 of their 9 children left the church, and in another family, 5 of 10 children also became inactive. The fallout from the dispute also created divisions in families. A year later, at a special meeting held in Goshen on September 1, 1881, Price was reinstalled as Goshen's bishop with George Gorley as his first counselor and Peter Ockelberry as his second counselor. Church leaders who attended the special meeting included LDS Church President John Taylor and apostles Wilford Woodruff, Joseph F. Smith, George Q. Cannon, Francis M. Lyman, Abraham O. Smoot, and John Henry Smith. Prior to traveling to Goshen, church leaders held quarterly conference meetings at Provo, Springville, Spanish Fork, Salem, Spring Lake Villa, Payson, and Santaquin. Isaiah Moses Coombs, who attended most of the meetings in the different towns, made no mention of what transpired in Goshen in his journal, although he noted that all of the church leaders' preaching was of a very practical nature and has a tendency to do a great amount of good. It is difficult to determine what, if any, action was taken against Mona ward members as a result of the lawsuit. In 1883, the Mona LDS church records were destroyed when the meeting house burned to the ground. Surviving records reveal there was not a significant number of rebaptisms during 1880 to 1881 and that the few persons who were rebaptized were not involved in the dispute. Mona residents are aware that a scuffle occurred between their town and Goshen in the 1880s, but there is no collective memory, as there is in Goshen, of anyone being suspended or excommunicated from the church over the dispute. Price continued as Goshen's bishop until 1896, when he was ordained a patriarch by Francis M. Lyman. He passed away on September 18, 1906, in Goshen. The Corres remained in Mona until the fall of 1881, when they returned to Provo because of Martha's poor health. Some of their children, however, found new sources for water, probably from wells, and they remained on the Mona ranch for approximately another 20 years. Martha passed away in Provo on December 14, 1881. After her death, Howard was called to serve a mission in Colorado. He died in Salt Lake City on January 16, 1908. In conclusion, the Goshen and Mona water dispute demonstrates the struggle between secular and ecclesiastical authority in Utah during the 1870s and early 1880s in such matters involving water rights. For most of the latter half of the 19th century, church members were discouraged from going to court against other church members. The Goshen-Mona water dispute demonstrated the contempt LDS church leaders had for the Gentile courts and their belief that church members should submit to a higher law. It also shows the struggle bishops faced as they tried to be the spiritual leaders as well as direct the temporal affairs in their wards and communities. Finally, it suggests that, although Mormons regarded water as a public resource, they were sometimes willing to acknowledge that water disputes between communities and individuals had to be settled according to secular law on the basis of prior appropriation. Virginia Sorensen's assertion that, in the West, people remember when important things were settled has proved true. In a desert state, like Utah, nothing concerning water is long ago.